Lordship, may kindly take the matter to
9.
9, Lordship.
We'll try to take it up before that. In fact, because there's a monitoring bench, we'll be sitting at 2.
Then, Lordship.
What do you call that? Is tentative for the single bench. It's tentative, but therefore at 2 we are not fixing it. Make it early.
Lordship.
Hmm.
Here, after starting hearing, Lordship.
Huh?
Hearing matter is from item number 2, Lordship.
Yes. We'll take it up. Don't worry. But not
Okay.
in the second half. Try to take it up in the first half.
My lord, I beg to mention for listing.
Listing, give it to the court master.
Oblige, your lord.
Daily list item 1 for admission.
May I please, Your Lordship, my lord?
Yes.
My lord, in this case, my lord, the mother of the petitioner was arrested, my lord, on 23rd of May, my lord, 2025, my lord. And since then, my lord, she is in custody, my lord. What happened in this case, my lord? Prior to filing of this petition, my lord, there was another petition, my lord, which was filed by someone else, my lord, putting into challenge the earlier expertise order, my lord. And by virtue of that petition, my lord, there is a specific order, my lord. I'd like to produce, my lord, before your lordship, my lord. Kindly produce it. My lord will kindly have a look, my lord. This is writ petition number 5498 of 2020, my lord. By virtue of which, my lord, this earlier expertise order was put to challenge, my lord, by the mother of the petitioner, my lord, who is now detained, my lord. And in that particular order, my lord, by virtue of order dated 22nd of December, my lord, 2020, my lord will kindly have a look in the third last paragraph, my lord, page 3, my lord. Last page, my lord. Until further order, the petitioner shall not be deported out of the country, my lord. This was a specific direction, my lord. And I was ignorant about this part, my lord, while preferring this present petition, my lord, filed by the petitioner, my lord. Petitioner's, my lord, he is the son of the, my lord, detainee, my lord. Despite that, my lord, this was brought into knowledge of the concerned authorities, my lord. Even then, my lord, the mother of the petitioner was arrested and she was, my lord, kept, my lord, in Kokrajhar, my lord, holding camp, my lord. Now she is in holding camp, my lord. Therefore, my lord, I am praying before your lordship, my lord, lordship will be pleased to, my lord, issue and, my lord, order, my lord, for release of the petitioner's mother, my lord. And earlier also, my lord, if your lordship kindly turn to page 33 of the petition, my lord.
Just give us that report. What happened to that writ petition?
That writ petition is still pending, my lord. I have mentioned in my petition, my lord, in the body of my writ petition, my lord.
Call that record.
My lord. But my lord was pleased to, my lord, state that, my lord, express that, my lord, lordship will kindly consider my interim prayer, my lord.
We understand, but you see, we have 2 writ petitions.
Yes, my lord.
One record is there. You could have requested us and we could have tagged it together.
My lord, because, my lord,
You see,
yes,
every
my lord,
time
lordship
when
will
we take up
kindly
the matter, we don't remember.
Yes, my lord. In fact, I made a submission, my lord, earlier occasion also.
I understand, but we don't remember. Unless we put it in the order, the record will not come.
My lord will kindly take both these petitions.
We'll take it up tomorrow.
Yes,
We'll get that record.
yes, ma'am.
That is WPC.
That is WBC 5498.
Also, it's represented. List on 3/12/2025 along with record of WPC 5498 of 2020.
My lord. Yes. 2020.
Just tell them over phone. Get the report.
Deeply obliged, my lord.
Supplementary item for orders WP Criminal 3/2025.
Lordship readers.
Yes.
I'm against a detention order, my lord, that was passed on 5th of December 2024 under the PIT NDPS Act. This order was passed on 5th of December 2024, my lord. The impugn order is at page 15.
Yes.
Yes, my lord. The impugn order, my lord, is at annexure 1, page 15 of my criminal petition, my lord. That's an order which has been passed on 5th of December 2024. The petition has been moved by the wife. The husband is under detention. May I just read, my lord?
How much quantity of narcotic?
My lord, in this case, quantity of human narcotics.
There are 3 cases against.
That quantity is not reflected here because this is a detention order, my lord.
There are 3 cases against him.
The 3 cases, my lord, which are pending against me, one has already been decided in my favor and have been acquitted. The 2 matters I am already on bail, my lord. They are mentioned at page 15. This is passed under 3(1), my lord, of the Act.
Yes.
Yes, my lord. I just read the first order, my lord. That is annexure 1, page 15, my lord. Whereas a police report and connected records have laid before the undersigned the Superintendent of Police, Gwalpara, Assam, by letter dated so-and-so, dated 19/7/2024, and dated 22/10/2024, whereas it has been proposed to detain Jahirul Islam, son of Atwar Rahman, village so-and-so, Assam, with a view to preventing him from engaging in illegal and harmful activities of illicit business of narcotic drugs and repeated violation of the NDPS Act, my lord. Whereas on perusal of the police report and connected record, it appears that the said accused has been persistently involved himself with a crime of illegal business in the narcotics since many years and was arrested in the following cases. My lord, the first case is of 2024, which is under 21B. So that is less than commercial. The next one, my lord, is 2017, which is the first case, my lord. That is a commercial quantity. This is, I have been granted bail. The next is, my lord, the Lokhimpur case, which is 296 of 21, which is 22C and 489B. But the charge sheet does not reflect 489B. It is only, my lord, the commercial aspect. In that also, I have been granted bail. The first case, my lord, I have already been acquitted. I have my lords, I have the orders. I'll pass it to your lordships. Subsequently, my lord, it says that it appears to the police that during the investigation seized particular suspected from substances in respect of the aforementioned cases were sent to the FSL for examination, and the report gave positive test of heroin, Nesafen, and methamphetamine. Whereas it is intimated to the Superintendent of Police, Gwalpara, by it report dated 19/7/2024. My lord, I am not in possession of this report of 19/7 as well as this 22/10/2024 because it's not been filed with the affidavit. That the accused so-and-so has been found to be a repeated offender under various sections of the NDPS Act 1985, and his detention under the PIT NDPS Act is imperative to keep him out of business of illicit trafficking and break the network of drug supply in the district of Gwalpara. So the indication is that, my lord, I am still continuing to do the business. My lord will now turn to page 16, my lord. This is based on this.
Keep you out of business.
Out of business. Out of business. Subsequently, my lord, the last paragraph, it says, the last line, my lord, has been acting in a manner prejudicial to the provisions of the NDPS Act by continuously indulging in illicit trades in narcotic drugs, even after his arrest several times, and therefore in exercise of the powers conferred under 3(1) of the so-and-so Act, hereby issue this order of directing that the above accused person to be detained under the Act until further orders, my lord. This was passed on 5th December 2024, my lord. Subsequent to this, my lord, at page 51, annexure 8, the wife filed a representation to the government.
Mr. Nath,
Lordship,
This 1 year is almost 2 days down the
Yes,
line, it's over.
today. Lordship. To the second, on fourth, my lord, 1 year will be over.
Otherwise, we also release, by the time we hear it and dispose of the matter,
We've tried, it was listed, and then
We
the
understand.
matter was heard, but then
we understand,
subsequently.
but the practicality of, we are not saying that you are incorrect.
Yes, my lord.
You did the right thing in making a mention and getting it listed.
I had no other
But
option.
the fact remains that there are only 2 days more.
2 days to go, my lord. I'm aware of that fact. In fact, we were slightly handicapped. Matter was heard,
But it's
reserved.
Okay, we understand.
That was the only reason I
It was hard.
heard and
it was-
reserved
it was
also.
Reserved also.
We are not blaming anyone.
Lordship.
It's the system to be blamed, but
Lot.
we are not saying anything.
Right.
In 2 days' time, the entire exercise which we'll be doing,
I
Will be
appreciate that.
utility.
madam. I appreciate that. We've tried our luck too much. It was listed a lot of times, could not reach for whatever reason. I'm not here to blame, but then that is how the procedure runs.
just a moment.
Yes, ma'am. Yes, ma'am. Purpose, my lord. Right. I cannot undo that. Until unless this order is further extended, my lord. I do not know. Should, my lord, in due course,
There is a provision,
there is a provision under the act.
section 11.
Section 11 says that, so that is perhaps one of the reasons why. Within the tenure, so it has to be passed before fifth, I think fourth, my lord.
Not yet. I have no information. Sir. No.
This exercise obviously couldn't be undone because I have already served. Suppose your lordship decides the fact that it is against, the detention is wrong. I am due faced with a trial of 1 year, which will be quite unfortunate, but then your lordships are correct. It will be more of an academic purpose.
Only today is a holiday. Today is a holiday. My lord. I have no information whether it is not extended. It is not extended. And only two.
Yeah.
Or lordship may keep it on fifth. On fourth, it will be over. On fifth, my lord, I'll just inform, but otherwise it will become infructuous then.
Yes, my lord.
Detention. That's true. That's
Correct.
That's-
Agreed.
my lord. Can you এটা তো উল্লেখ করলে 5 থেকে 10% হয়ে যাবে, এটা
My lord. Yes, ma'am. My lord. My lord. Right, ma'am. Right. 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 There is 2 or 3 judgments, my lord, which I'm referring, which is basically on the 2, 3 grounds. I can give a note also if required, my lord, that will be.
one ground is enough. Lordship, lordship, lordship.
Right.
Lordship. I have gone through the decision lordship, judgment lordship has passed on the other day.
The fact also that remains
So
that
many grounds have been taken, lordship has decided in one ground. That is enough. Lordship.
my only ground of 3-2 violation remains, because that is something that I wanted your lordships to just go through it if it is not. The order that has been passed, my lord, is passed under 3-1. Now there is your lordships will come to 3-2 of the act, my lord. Three, two, my lord, for your convenience. 3-2 says when any order of detention, my lord, is passed by the state government.
No, like what to peaceful is it with peaceful is it. The date we activate page number to put. Page number 73 for it.
It's the same act. It should start from page 77, my lord, because this is the second part of the act. Yes, my lord. Page 78 is subsection 2, 3-2, my lord. When any order of detention is made by the state government or by an officer empowered by the state government shall, within 10 days, forward to the central government a report in respect of the order. My lord, 3-1 says that the order has to be made by the state government or a central government who is empowered. But there is also a mandatory requirement that there is a report which has to be submitted to the central government. In this case, my lord, my respectful submission is that that order is not available and has not been passed, because that is a report which has to be passed and sent to the central government. Though the order at page 16, my lord, says that the order has been marked to the central government at page 16, my lord. Yes, my lord. 3-2. On the ground. 3-2, my lord. So the report is what is to be. No,
At your pleaded case.
no, my
because
lord,
three
it's
two,
not been
I-
pleaded. It's not been pleaded.
I missed
It's
it
not
out.
been pleaded. It's not been pleaded. So that is one ground, my lord, which I had.
Because you see, come to page 61,
Yes, my lord. Of my petition, my lord.
no, it will be the affidavit of the central government.
Yes, my lord. Yes, my lord.
Come to paragraph 6. At page 61.
Yes, my lord. There is a
You
slight
see, it
difference
says
in
in
the
exercise
text.
of power under 3.1, the detained authority rely upon police record, relevant reports, and the recommendation
ma'am.
of the SP Gwalpur and being satisfied.
Yes,
Let
that
me
is the
see.
report which is mentioned in that order itself of 19 July and 2210. I pointed out, my lord. That is at page 15, my lord. The two reports of 19th of July and 2210. That is the report which has been submitted in terms of passing this order, by which that order has come to effect. 3.2 says, my lord, once the order of detention is passed, it has to be mandatorily sent to the central government under 2. That is what I was trying to point out, my lord. If your lordship should again go back to 3.2,
Are 2 reports required? I don't think so.
that's what it says, my lord. With my understanding, when any order of detention is made by the state government, my lord, or by an officer empowered by the state government, that is the order of detention, my lord, under 3.1 and 3, which has been passed
Yes.
by the state government, shall within 10 days forward the report to the central government with a report. So that means once the order is passed, my lord, there has to be a report which has to be sent to the central government. These two reports, my lord, which are referred here, are also referred in the 1512 order, are the reports filed by the Gwalpara police, my lord, which is,
So now we understand what has happened.
yes,
Why it is not, I was mistakenly reading that. 1 and 2 I thought was Union of India. Union of India is not a party here.
no, it's a state government, which is
State government.
which is
So
empowered.
whether these reports were compliance were made or not, that we don't have a way to get the
No,
information.
normally it is supposed to be complied, because if it is state government who files it, who's empowered it, because there can be investigation by the central or the state. That has to be forwarded, which is mandatorily required to be done, because the word used is shall. That is what it says.
Even otherwise,
Yes, ma'am.
because even otherwise,
Yes, ma'am.
if the central government is not a party, and we
Yes,
don't
ma'am.
have a
It's not a
report,
party, no,
and if it is not the pleaded case
Yeah.
for 3.2, then the reply is not there.
not available. But
So-
only wanted to point it out because this becomes mandatory if the order is passed under 3.1
No, we understand.
by the
but
state
see,
government who's
unless-
empowered to do it.
Unless we ask them to respond.
Yes, I'm not aware of that. On the last occasion, it was
So it's
argued.
okay, but if we don't ask them to respond to it.
Right, my lord.
That
That is
cannot
one
be a
ground,
ground
my
to
lord. Right, I agree.
question.
I agree, your lordships. I
We
agree.
Come on to the second point.
I understand. Number 2, my lord, in all the cases,
This is the application of mine. Anybody want to? Have you been given or that before I leave? This is different from the application.
Because, Mr. Fukan, I'll be fortunate to have my sister here in the bench. In Nagaland, the NSA and detention matters.
yes, ma'am.
The
common.
lawyer community would be very, very strong. And and
So invariably, the Union of India has always made a party in NSA detention, PIT and TPS also. So,
she has handled lot many cases
Yes, ma'am.
while standing there.
Yes.
So that's why all these reports and all, everything would come from the affidavits of
Yes, yes,
the
I agree.
Union of India.
I agree. I was only pointing it out because that it follows in that part that 3.1 and 3.2 has to be read in consonance, because the power is ultimately delegated to the state government.
But maybe if that is not the pleading case, we.
Yes, my lord, I agree. I just wanted to point out to your lordships, that's all. Number 2, my lord, the 3 cases which are mentioned in the 5th of December order, my lord, at page 15 of my petition, my lord. In all the 3 cases, my lord, the bails have been granted. The first case, my lord, which is, I have pointed, lordships had those bail orders, is 11/6/2024, my lord, which is PS 30 of 2024. In that also, my lord, I have, this is 21B, my lord. So this is less than commercial, 60 days. The next case, my lord, is 16 of 21. at the third page, my lord, of that order. This is case number 16 of 21, my lord. This also have been. Third page, my lord.
One,
Not for this case, but there's a blunder by the state police.
lordship.
You have a copy of this order 23-9.
Yes, my lord, I have an order of the
Go
copy.
to
Yes, my lord.
I think this is something that we will have to track.
Mal-
Every time the court cannot make comments,
mal-
will not be taken in a good good spirit. You see, 23-9-21,
mal-
accused person is paragraph 2, under 21B, 22C and NDPS Act. Correct?
lordship.
Now come to next page, CL number 7. 9 lakh rupees suspected counterfeit Indian currency notes.
Correct.
For that, there is no prosecution.
No. In fact, in the next page, my lord, it specifically says that after, I was just about to read that, my lord. After considering the material on record and having heard both, I am of the opinion there is a ground for presuming that the accused person have committed an offence under 21B and 22(9).
So you understand, that's for the state to.
Yes.
Yes, need size.
Only they confine themselves only to NDPS.
It's for the state to say.
Lordship.
you-
In fact, the order of 512, my lord, reflects as 22C.
No, lordship.
That is also not
Any comment.
application.
It is for you to take it up with the state government. This is happening,
But-
the police has to be trained.
Lordship. Absolutely. Absolutely.
Yes.
So that only try to reflect that this order, which has been passed in a mechanical manner, and the fact that the 512 order is, my lord, is without a trial, will have to, the state has to express the most concern when he's passing an order. Both, all these matters, my lord, under section 37, I've been granted bail. So this is a presuming fact on 2000, last bail is in August 2025. So in a span of 4 months or 5 months, this order has been passed subsequently, my lord. That's the last bail order. So 11/6/24, my lord, of 30 of 2024, the first order which I've handed over, my lord. So within the span of 5 months, this other order has been passed based on the 2 police reports, which is much of October and September, my lord, which is reflected on the 512 order. Of July and October. So most, even that, in fact, in Banik's judgment, my lord, they have specifically said that that has to be considered if after section 37, any orders are
But
made.
this, otherwise you see, this order at page, the 23-9-21.
Yes, my lord.
Please come to page 15 first.
Yes,
of
my
the
lord.
exception. Here there are reference to 3 cases.
Yes, my lord.
This is a special case at Gwalpara,
Yes, my lord.
15 of 21.
296, my lord.
And in this, the serial number 1, 2, and 3, Krishna PS, Lakhipur PS and Lakhipur PS, are they related to the trial of this special case 16 or 21?
No, my lord, they are two different. 296 is 23 of 9, my lord. That's the order which is passed. And the subsequent case 292, my lord, there is another order. 292, my lord. 292 goes to Kotala. 292.
Look, 21 matter.
This would be Lakhipur.
Lakhimpur, my lord, this is 292 of 2017.
So two are from Lakhipur, so this is the fourth case you are having.
No, my lord. The third case is, my lord, that the order of the High Court, my lord, is 27th of March 2017, the last order that I've given, my lord.
No, I'm, you see, I am juxtaposing it with page 15.
Right, my lord.
15 is Krishnai.
Yes,
Krishnai would be Gwalpara.
Gwalpara.
Lakshipur
Lakshipur, Lakshipur,
is again, Lakshipur is again Gwalpara.
Lakshipur Gwalpara, my lord, again, yes. There are two cases there.
Two cases there.
Yes, ma'am.
This special case 16 or 21,
Yes, my lord.
this appears to be the fourth case here.
But there are only three cases, my lord.
No, it's anytime.
This is the fourth case. We'll tell you why.
Yes, my lord.
My esteemed sister has found it out. You see, come to the High Court order.
Yes, my lord. Which says
It's
GED
under
number.
Section 21A.
Yes, my lord. That is the GE number that your lordships are referring to.
Section is 21A.
Yes, my lord.
21A is not reflected in page 15.
Yes,
I
my lord.
don't know.
The FIR is 502 of
We are
2017.
not on that.
G,
You
yes,
see,
ma'am. I understand, but
Cross-examining,
yes, but it only reflects.
21A.
No, your lordships are right.
21A.
Your lordships are right.
So
That this is
21A
the
would
fourth
be the fourth
case.
case against you.
These are three cases mentioned here.
Yes.
No,
Can we use the word incorrigible?
no, to the Belek case, you know. I think, my lord, it's the same case, but there seems to be some mistake on that because
No, it can't be.
the GD entry
No,
number
no,
looks to be the same in
What
the
happens
FIR.
is that no. This is GD entry.
Right, my lord.
41A it refers to. Once it is entered,
Right, my lord.
it is only at the time of charge sheet that the police will say that there is no case under 21A is made out and
Right.
therefore charge is accused is charged under section 21B and 21C. They at the time of GD entry or police case entry, they will not drop a section.
Right.
Normally not done.
My lord, the charge sheet that I have, which unfortunately not been filed with me, is 21C. It reflects as 21C.
But this is
Same
21
case which reflects here.
This is 21A.
Yes, my lord, it reflects to be the. Here it says 21C, my lord, for some
And
reason.
this is 21A is for a reason. Come to
Yes.
the next page.
Yes, my lord.
The second paragraph, it is contended that the accused petitioner is a medicine wholesaler and so and so. Therefore, the drug which is seized must be cough syrup.
Yes,
So
my
that
lord.
is why 21A,
Yes, my lord.
licensed but exceeding quantity.
Hmm. Fortunately, it looks like, Manoj, because the GD entry here is 502, everything looks to be the same 21C. For some reason, it does not reflect that.
We are dealing with two trial court people.
No, I agree, my lord. My apologies for that, but here it reflects what it is mentioned here in the High Court order, so I thought it was the same case. And the third point, my lord, that I was trying to let you, this is the representation that the wife has given. The representation was actually forwarded, my lord, on 8th of January by the wife. That is at page 80, annexure 51, annexure 8, page 51.
Yes.
In this manner, this was subsequently only decided on 10th of April 2025, after the advisory board set and passed the order on 17th of February. So this should have, my lord, with a humble respect, should have been decided early because this was pending for quite a long time. And before the advisory board's order had come, it should have been taken care, but this has not been dealt with. And there are, this lordship shall point out a judgment where it specifically says that the representation should be decided at a time. Yes, otherwise there'll be a violation. 9. And in here, my lord, I specifically say that in all the three cases, I've been granted bail. Husband has been granted bail. Subsequently, my lord, that order of rejecting. The representation, my lord, the disposal of the representation is 10th of April 2025, my lord. That's at the affidavit filed by the government.
Yes.
Yes, my lord. I'll just read one part of that order passed on 10th of April, my lord. Passed by the rejecting my representation, my lord. There's a small difference, my lord. The pagination, I think, are slightly different. On the last occasion, it was pointed out, but since the matter was reserved, we could not correct it. In my page, it is 65 annexure A of the affidavit filed by the
In
government.
the brief, it is 68.
Yes, my lord. I just read that second paragraph, my lord, where this says averment 5 and 6. It says, whereas the averment made in para 5 and 6 are found not to be justified for revoking the detention order, as it appears to be seriously detrimental to a large number of people of the Gwalpara district. The release of Jahirul Islam may again lead to restart of illegal trafficking of narcotic drugs and other substances in Gwalpara, as is one of the main conduits through whom the drugs are supplied to the district in a manner prejudicial to the provisions of the Act. His detention is also necessary so that the other traffickers and peddlers are also deterred from supply and sale of narcotic drugs and substances to the innocent and to protect the younger generation of the state from millions of drugs and district spread. So this is a finding after the report which has come passed by the advisory board, my lord, which is subsequent to that. In my page, my lord, it starts at 74. The order is passed on 17/2/2025. It is is 77, my lord, if I'm not wrong. It should be.
Yes.
Yes, my lord. That is the report which has been passed, my lord. All the three cases are discussed, my lord. And at page 76, which is my page 76, my lord, the second paragraph, around 10 lines from the top, my lord, it says, during investigation, you so-and-so has been arrested after proper interrogation. My lords have it. Lordships
Yes.
have it. Page 76 of my, 10 lines from the top, my lord. During investigation, you so-and-so has been arrested, and after proper interrogation, it is found that you are involved in drugs trafficking all over Gwalpara district. This refers to PS case number so-and-so 222C of NDPS and 49489B of IPC. From the three cases of so-and-so, the three cases are mentioned, my lord. And then it says at the last paragraph, my lord, the detainee has stated fully understood the grounds of detention. The detainee has further stated that the detaining authority informed him about the serving of the order, about his right to make a representation to the authorities, naming the detaining authority, the advisory board of the state government or the government of India, which are mentioned in the ground of detention. The detainee stated accordingly that under his instruction, his wife, Rabia Khatun, that is the petitioner, my lord, has submitted a representation to the Additional Chief Secretary Government of Assam Political Department through the Superintendent of Police, but the outcome of the said representation is not known to him. The detainee has further stated that he has been in jail custody from 1912-2024. He was detained before he was released in all the bail cases of three cases, one Krishna PS and two Lakhimpur cases, to court bail orders. His detention was forthwith informed to his close relatives, so-and-so. He was stated that he was falsely implicated in a number of cases. So the cases that are mentioned here are already three. In my lord, with the reference of that case of GD entry, my lord, this is an order which I have just now passed that will clarify that the GD entry case, my lord, because it reflects here as 21C. That is, I just got that order. I thought I just pass it on to your lordships. This is the case where I've been acquitted. Right. Subsequently, my lord, they come to the conclusion at page 77, bottom, my lord, that the evidence on record establishes that the detainee has an habitual drug trafficker. He has, as a whole, track record of criminal antecedent, as stated in the grounds of detention. We therefore find that the detaining order, having satisfied the conditions incorporated in Section 3 of the Act in respect of the detainee and literally following the mandate of Article 22 of the Constitution, has rightly passed a detention order, preventing him from further engaging in illicit trafficking of narcotic substance, causing serious threat to the society, health of the society at large. So this is the conclusion that they came in, and subsequently the opinion has been expressed that unanimity of the opinion of the board constituted under this act, that there are sufficient grounds to detention of so-and-so case under subsection 1 of 3 Prevention Act of 1988. So this was the order passed. Now, in terms of this, my lord, the two judgments that I was referring to, my lord. One of this High Court only, my lord, which refers to similar facts. The first judgment, my lord, I'm relying is of WP 20 of 2022 passed by this court itself, my lord. एक कॉपी का देने दो यार, कॉपी का ना लिया बेगम ये तो लोग नो just read the first paragraph, my lord. By this petition under 226 of the Constitution of India, the petitioner has challenged the order of detention passed on so-and-so by the Commissioner so-and-so under 3(1) of the Prevention of Act 88 and has spread that the respondent notice be directed to release the detainee who happens to be the husband of the petitioner without any further delay. The facts, my lord, this is important because in a similar situation like us, the petition is filed a writ of habeas corpus by the wife of the detainee who has been detained in jail from 18/4/2022, passed by the Commissioner Secretary Government of Assam under Section 3(1) of the Act. The record indicates that the order of detention of the husband petitioner has based on his involvement of 3 cases. So in this case, also 3 cases were mentioned, my lord. Number 3, it is the case of the detaining authority that detainee is lodged in Central Jail, Guwahati, and is likely to be released very soon, and therefore it was considered essential to detain him under the Act. The order of detention was served upon him on so-and-so date. The record indicates that the petitioner has filed a representation on behalf of the detainee, the husband, on 7/5 to address to the Commissioner Secretary of the Government of Assam, Guwahati, and a copy of thereof has also been marked to the advisory board and to the Secretary PI Minister of Finance in New Delhi. It also appears that prior to filing the representation on 7/5/2022 by the petitioner, the detainee has also filed a representation to the Commissioner Secretary Guwahati. Both the representation can be disposed of on 20th of June 2022. The petitioner, as the wife of the detainee, has preferred this petition on various grounds. More particularly, it was contended that the impugned order of detention is based on total non-application of mine on part of the detaining authority that is violative of Article 21 and 22 of the Constitution. It is also averred in the petition that even though in all the 3 cases which are referred in order and detention in 18/4/22, the detainee has been enlarged on bail by a competent court, including this court, and the same has not been considered. And on contrary, involvement of the detainee in those 3 cases have been made the very basis of passing of the impugned detention order. It is also contended that the representation filed with the petitioner and the detainee have been considered after much delay under violative of Article 21 and 22 of the Constitution. On such ground, it is submitted to the petitioner that the detention order may be quashed. Similar ground, my lord, my representation was sent on 8th of January 2025. It was subsequently disposed 24, and it was only disposed in April 2025 after 4 months. In terms of this, my lord, this court has come to this conclusion. The rest of them are reference of all the other cases in the judgment has been referred. I'll come to para 11, my lord. It is a matter of record that the order of detention dated so-and-so, where is its admitted position in Gorsuk case number so-and-so. Detainee was enlarged on bail by the Session Judge Kamrup Guwahati by order dated so-and-so, much before passing of the order of detention dated so-and-so. Similarly, the second case, Bolumuk, also registered against the detainee for offence of 22B, a learned single judge of this court enlarged the detainee on bail by order dated so-and-so in bail application number so-and-so. And again, in the third case, the Panbazar case, the detainee had been enlarged on bail by the additional Session Judge number 5, Kamrup Baide. This is an admitted position in that all the cases have been made on basis of the detention order. The detainee has been enlarged in bail. At this juncture, it would be appropriate to refer to the order passed on 20th of June 2022 by the Commissioner Secretary Government of Assam Department, in where reference is made to the communication made on 7/5/2022 to the Superintendent of Jail Guwahati to the detaining authority in relation to the representation dated 2/5/22 filed by the detainee and the representation 7/5 filed by the petitioner, informing that the detaining order has detained is in jail in connection with so-and-so case number. It is a matter of record that when a bail was granted to the detainee by a competent court, the state was being represented by a public prosecutor, and therefore on the date of detention order was passed, that is 18/4/22, the detaining authority had constructive knowledge of the fact that in all the 3 cases which has been made the basis of the detention order, the detainee is already enlarged in bail, and therefore the very mention in para 9 that he is in jail in connection with all the 3 cases exhibits total non-application of mine on part of the detaining authority, which renders the impugned detention order vulnerable and likely to be struck down. As the impugned detention order is passed much after detainee was enlarged on bail in all the 3 cases, the same lacks application of mine. On all the grounds mentioned above, the impugned order dated so-and-so smacks the total non-application of mine, and the same is violative of Article 21 and 22 of the Constitution. Secondly, it is noticed that the detainee filed a representation on 2/5/2022 and the representation filed on 7/5/22, copies of which were sent to the concerned authority, including the advisory board. Whereas the same were considered and rejected by the order dated so-and-so by the Commissioner Secretary so-and-so, the rejection of the representation filed on 19/7, almost about 75 days. Thus, the detaining authority, as well as the central government authority, has considered the representation filed by the detainee, as well as the petitioner's next minor detainee, in delayed manner, which is prejudicial to the fundamental right of the detainee under Article 21 and 22 of the Constitution. My lord, now, paragraph 17, my lord. The case in hand is also the passing of the detention order. What was considered by the detaining authority as basis of an order was the 3 pending cases wherein the detainee has already been enlarged on bail, a fact which is totally ignored. Hence, the judgment of the apex court on Yamun, Wongbi, Lembi, has squarely applies to the present case, as the representation made to the advisory body remained undecided and the same is not brought on record by the respondent. The ratio laid down in Soendo is also applied to the present case. We've been considering the ratio laid down in the apex court in Sheila's revision and Ahmad Ali Soendo, as well as the single bench's order. The order of the impugn order is violative of Article 21 and 22 of the Constitution of India. My lord, the similar view has also been taken in the second judgment, my lord, which I have referred, is Jahanara Bibi, my lord. This is the Calcutta High Court judgment. Both the Supreme Court orders are referred here, my lord. This is also an habeas corpus petition file. I'll read draft 15. I just read para 14, my lord, because that speaks about the quantity also. The petitioner was arrested on 3 separate occasions for 3 separate cases. My lord has para 14. The fact that the such case was regarding 1.01 kg of heroin and the second being the constructive possession of 30 kgs of ganja along with her associate. The third aspect is the 7 kgs of ganja seized from her residence. We say constructive possession since a courted bench of this honorable court has held that ganja was recovered from her co-accused and she was arrested on the basis of a statement of the co-accused before the IO. The money recovered also could not be traced as to the alleged transaction. These findings in the order dated so-and-so may leading to grant of bail not even challenged. Thus, the petitioner in all the 3 occasions were granted bail by the court of a competent jurisdiction, including the High Court of Calcutta. The petitioner has challenged the retaining order on 5 September 2024. The order was referred to the advisory board, appearing the respondent produced the original order of the advisory board, which is perused and returned to Mr. So-and-so, keeping a copy on record. The opinion rendered by the advisory board of the state of Jharkhand is a bare confirmation of the detaining order. The finding of the detaining order which led to the passing of 15th enumerated hearing. Number 1, the petitioner is an habitual offender. Number 2, the petitioner is involved in trafficking in narcotics, drugs, and psychopathic substances. Petitioner is a propensity of an involved in prejudicial activities in the future. And petitioner is a threat to the innocent person of the locality and her activities are prejudicial to the society. The same contention which is also expressed in the advisory board's order. The detaining author came to the conclusion that the petitioner being a habitual offender could probably indulge in such activities of trafficking if not kept in preventive detention. Subjective satisfaction relates not so much as to why the petitioner should be kept in the preventive detention, but more on the factum of the petitioner has been involved in trafficking over a period of time. The detaining authority has come to this finding even after the petitioner has been jailed in 3 criminal cases. The finding of the detaining authority is more on the petitioner's alleged crime than on its satisfaction that the petitioner needs to be detained, which is a bare observation regarding his propensity of the involved in such trafficking. The conclusion that the detaining authority, the petitioner is an habitual offender, tends to put the cart before the horse, as the petitioner has not been held guilty in any of the crimes that she has been charged. The Honorable Supreme Court in the judgment of 2021 9 SCC through 1415 has clearly held that apprehension of a repetition of a crime cannot be a ground of preventive detention. A close reading of the detention order makes it clear that the reasons of the said order are not on any apprehension of public harm, danger, or alarm, but merely because the detainee was successful in obtaining a bail order from the court by a competent jurisdiction in each of the 3 FIRs. My lord, I'll skip these 3 parts. The next important is para 25, my lord. Here it refers to Asima Begum, my lord, the parameters of the 3-1, which has been laid down by the Honorable Supreme Court, my lord, and then 25. The petitioner went through the rigors of Section 37 of the NDPS Act, and even after being, I'm sorry. Yes, my lord. Yes, my lord. The order of detention is 5/12/2024, my lord. Annexure 1 of the writ petition. 5/12/2024, my lord. Yes, my lord. The first case, my lord, 30 of 2024. Is, I'm going to.
17 to take.
That is, my lord, we've got bail on 11/6/2024.
The last case.
21 case, my lord, we've been granted bail on 23rd of September 2021. And the last case, my lord, which is 17, is on 27th of March 2017, my lord. 2017, that's a 2017 case, my lord. Yes, para 25, my lord, I was reading, the same, para 25, my lord, the same judgment. The petitioner went through the rigors of section 37 of the NDPS Act 1985, and even thereafter was granted, I'm sorry. ma'am. I'm sorry, just para 25, ma'am. Lordships have it, this is long command. The petitioner went through the rigors of section 37 of the NDPS Act 1985, and even thereafter was granted bail on the 3 separate occasions. In fact, for the third alleged crime, possession of 7 kgs of ganja, the application of cancellation of bail was also rejected by the bench of this honorable court. Thus, there is no reason to construe that the rigors of section 37 of the NDPS Act has not been taken into consideration while petitioner was granted bail. The authorities presently cannot override the grant of bail and make a present order detaining her on self-ground on which the petitioner has been granted bail. My lord, the 2 judgments are referred, Amina Begum as well as, I'll pass on that judgment to your lordships. 28, my lord, paragraph. The law of prevention detention has espoused to various decisions of the Honorable Supreme Court of India and several high courts of this country. They are all in edim and on fundamental issue that prevention detention is an aberration of the right of freedom of an individual's personal liberties. Thus, to give credence to such an aberration, that the prohibitive value of the materials on record must be on a higher order to justify suspending an individual's right to freedom and liberties. It is a well-settled proposition through the years of judicial pronouncement in the late of 2025 by the Honorable Supreme Court of India that prevention detention is an extraordinary power in the hands of the state, which must be used sparingly, and as it curtails the liberty of an individual in order to prevent an anticipated commission of an offense which could disrupt the public order. Needless to say that the preventive detention is an exception to the Article 21, therefore must be applied in rare of cases. Any order of detention on basis of an allegation prior to a conviction is nothing but an invasion of personal liberty of an individual and should therefore adhere strictly to the statutory requirement, even stricter procedural and substantive safeguard as envisaged in Article 22 of the Constitution. The Honorable Apex Court on several of its decisions has reiterated the power of preventive detention is a necessary evil and must be exercised only within the strict statutory and constitutional confines. The detaining authority must have a contemporaneous and a relevant material to which an application of mind without relating to any conjecture and assumptions must be shown. Keeping in mind that the limited scope of interference in judicial review, we cannot turn a blind eye to the detaining authority's mechanical adoption of a recommendation given by the police authority, which is also in my case of the 2 orders that are reflected, my lord. A mere line that the petitioner enlarged into civil society may give rise to threat and harm to the society at large is wholly insufficient and inadequate to suspend the personal liability, the liberties. There is no change in circumstances from 2020 for the arrest of a commission of the first alleged till 2024, the date and commission of the last offense till January 2025. Thus, preventive detention cannot be exercised as a punitive state, which is detaining an authority has sought to do in this manner. The legal distinction between preventive and punitive detention is well established. The former aims at to forestall the future prejudicial acts, and the latter is to punish the past ones. Yet, from the point of detaining, The practical reality is the same: loss of liberty, separation of family, and confinement to prison walls. Indeed, preventive detention imposed without a trial can be more intrusive to a person's liberty than the preventive detention. This is why the Constitution and the statute subjects to order of strict safeguard, and why the Supreme Court has cautioned the preventive detention must not be used as a convenient substitute for punishment under the ordinary criminal process. What is the real object is to inculcate the past offense as to continue to dispute the custody. Despite a court granting a bail, the order loses the preventive character and becomes unconstitutional. So, my lord, in this case also, there has been no application that has been filed for cancellation of the bail in this order also. So this is an absolutely purely administrative order which has been passed. This refers to the two orders. My lords are already aware of that. I'll pass on to that orders, my lord, which is the Banik judgment and as well as the Asima Begum, which is the parameters laid down. Yes, I have already submitted. I think your lordships are already aware of that judgment. I will not waste your time. That I have already passed on. The Banik judgment is also reading on the realms of 37, which says that once that is gone through, that order will have to be kept in mind before passing any such order. Those two judgments I have already referred, my lord. I have an Asima Begum, my lord, which lays down the parameters of the preventive order passed under Section 3.
Lordship.
I'm doing.
Lordship.
Basically, the last and third point.
On the third one, Lordship. Well, the well, the third, the point taken by the petitioner is the representation, non-consideration of representation. In fact, in the writ petition, the pleaded case is that the representation was filed and that has not been considered by the authority. That is the pleaded case, and in our affidavit we have said, my lord, that it was rejected. If lordship kindly take note of para 12, my lord. They said that a representation dated 8/1/25 has already been made before the respondent number 2 for revocation of the impugned order dated 5/12/2024, and for releasing the husband of the petitioner. The said representation is submitted through the SP, the Superintendent of District Jail, Gwalpara, Assam, and the same has already been forwarded by letter dated 15/1/2025, but till date no action has been taken up, and the representation of the petitioner is still lying before the respondents. To that, my lord, we have filed our affidavit. We said that it was rejected on 10/4/2025. As such, my lord, the delay in representation was not pleaded, but that has been argued, my lord. Lordship may kindly take our affidavit, my lord. Since it was not pleaded, my lord, we have not
Effort of the state is half-hearted. In this 10/4/2025,
Lordship.
you see insofar as this representation is concerned,
Yes, my lord.
that is a representation of 8/1/2025.
My lord.
This writ petition was presented before the registry on 5/2/2025.
Yes, my lord.
So the disposal is in 10/4,
10/4.
which subsequently. On that day, it was not disposed of.
It was not.
And in this, even in this 10/4 letter, you don't enclose therewith the proof of service.
But in fact, they have not.
You'll have to transmit it and serve it on the detinue.
Yes, my lord. In fact,
That
the superintendent of police, he was informed, my lord, page 69. Kindly come to
every
page
government
69.
order, everybody doesn't comply. Unless you show us a proof, it's a preventive detention cases. time is of utmost importance.
Well, they have filed a
This gap
reply.
you will not, this gap you will not find in the cases where the DRI takes over.
Lordship.
You will find them giving the proof of the service.
Well, they have filed a reply. And in the reply, my lord, they have not said that they have not received it.
No, that's okay.
Lordship. In any case, my lord, now, my lord, they have argued, during the course of hearing, they have argued that there is delay. Well, on that point, my lord, Lordship, I would like to refer from the affidavit in opposition from the detention order, my lord. Kindly come to page 68 is the detention order, annexure A, my lord.
Yes.
Here, my lord, few dates, my lord, I have to refer it from here only. 65, it will be 68, my lord. Lordship,
No, because one copy is corrected, one copy is not corrected.
Lordship.
That's why my
At the,
copy is having 65, I
at
am
the-
having 68.
at the time of
It's okay,
filing, my lord,
it's okay.
we may,
Doesn't matter to us.
we have given page 65, my lord. Lordship, the representation was dates are, my lord, kindly take note the date, my lord. On 8/1/25, the representation was submitted. And on 15/1, my lord, where is the representation dated 8/1/2025 submitted by Rabia Khatun, wife of Pete NDPS detainee so and so, as received from Superintendent of District Jail Gwalpara by letter dated 15/1/25. So on 15/1/25, the superintendent has forwarded it to us, the government, my lord, along with the Paravine's comments submitted on the representation by the superintendent of police. This
See,
is on,
that itself is a ground. You will not go anywhere else. 8 representation goes to you on 15, that is 7 days.
Lordship.
That itself is a ground to crash it. You see, unless you rectify your own system within the police
My lord,
administration, this is bound to happen.
Lordship.
Your administration will have to take very strong steps
They have to,
so as to educate your or refresh the memory of your jail authorities
Lordship,
on the requirement of immediate transmission.
my lord.
Either you don't provide them with the communication facilities. That means perhaps their scanners, emails, they are not working. Otherwise, this should have been transmitted the same day.
My lord,
Unless the government takes steps,
Lordship.
they're bound to happen. 7 days, it's fatal. Our court has held 4 days to be fatal.
My lord, these things, my lord, absolutely, my lord, these are to be looked into, and as per record, my lord, on 15/1, my lord, it was forwarded to the government. Then, my lord, government has sought a report from the Paravine's comments on the representation from the SP. The second sentence, second line, my lord, below that, on 10/2/25, my lord, the Paravine's comments from the SP has come, my lord, on 10/2. Then, my lord, Lordship, just the opinion of the advisory board in the meantime was received on 17/2/2025. My lord, here, my lord, I would like to indicate, my lord, that in the meantime, the matter was referred to the advisory board. The advisory board reports we have placed, my lord, and this Lordship will find at annexure B at page 67 we have mentioned, and it will be page 70, my lord. Here, Lordship, the advisory board is in session of the matter at that point of time. The entire record and all, everything was placed before the advisory board at that point of time, my lord. The advisory board kindly come to page number 68, my lord. It will be 71. On 21/2025, in the meantime, in the month of January itself, my lord, it was placed before the advisory board, because the advisory board, if advisory board is of the opinion that there is no ground, ultimately, my lord, he will go out. So on 21/2025, advisory board has fixed the matter on 25/1 and 26/1, and also directed that the officer concerned to be present here, my lord. The advisory board has said, in fact, at page 68 itself, my lord, the last para, representations, if any, submitted by the detainee, along with its disposal order by the government, shall be placed before the advisory board on the date fixed for hearing of the detainee. But at that point of time, the entire records were with them. Subsequently, it was refixed, matlab, date was refixed because 26, matlab, the police officer could not come. It was a Republic because of the Republic Day program, matlab. It was fixed on 7/2 and 8/2. Then, matlab, the report finally came at page number 74. It will be 77, matlab, on 17/2. So till 17/2, the records were with them, the advisory board. After that, matlab, the advisory board's report, the records have been, matlab, sent back. Annexes C, matlab, page 79, it will be 82, matlab, page 82. This is after the advisory board report, the confirmation of order was issued by the authority on 25/2/2025. So till 25/2/2025, matlab, the records were with the authority for before the advisory board, as well as the authority for the taking up the matter for confirmation of the order. Thereafter, matlab, it was taken up and the representation was, along with the parawise comments, it was considered, and on 10/4, the order was passed. Fine. मतलब इस सब्जेक्ट पे छोटे कितना कोट लगा है यार ना ना यार ইচ্ছা করে এটা বহুত কিছু আমার যেটা অর্ডার করতে সেই অর্ডার যেটা করিল আমি আমি না না মই হেৰি এইটো 68 রিপাবলিক ডে আমাকে রিপিট করতে হবে 26 রিপাবলিক ডে পুলিশ আহিব নোৱাৰিলে মালক
Any authority on the point, by any court saying that the authorities who are required to dispose of representations can abdicate their or postpone their decision merely because the records are with the another authority. We'll give you an example.
that
My examples are always horrible, so I'll just.
lot. So matlab, that is how matlab, the representation was finally considered on 10/4/2025. And in fact, the second ground matlab, they have taken as regard the bail orders. It is the submission has been made that the bail orders were granted and the authorities there is non-application of mind while while passing the detention order, my lord. To that effect, lordship may kindly see the detention order itself. In fact, they have considered, my lord, that the petition the detainee was under bail. He was on bail, my lord. Lordship, the grounds of detention, Lordship will find at annexure 2 in the writ petition, page 18. There, kindly come to serial number 6, my lord. These are the three cases they have considered. While referring to the three cases, they said, it is seen that you have involved yourself within the crime of illegal trafficking of drugs since long in Goalpara district. You are engaged in illicit trafficking, thereby turning a large number of youths into addicts, harming not only the health and future of the youths, but also deprive the nation from quality human resource, which will have detrimental effect on the society at large, besides encouraging such addicts into other criminal activities. Further, it is observed that you are found to be a habitual offender of such illegal drugs trafficking in violation of the provisions of the NDPS Act. In spite of your arrest in different cases, you neither mend your ways, nor you have shown any remorse for your criminal acts, and you continue to get engaged in criminal activities with the help of your accomplice. At present, 7, but at present, you are not in police remand and you have been released on bail. Though you were in judicial custody in connection with the above mentioned cases, your release on bail appears to be seriously detrimental to a large number of people of Goalpara district. Your release may again lead to restart of the illegal trafficking of narcotic drugs and psychotropic substances in the district of Goalpara, as you are one of the main conduits through whom drugs are supplied to the district in a manner prejudicial to the provisions of the NDPS Act 1985. Your detention is also necessary so that other traffickers, peddlers are also deterred from supply, sale of narcotic drugs and substances to the innocent youths. To protect the younger generations of the state from menace of drugs in the district of Goalpara, your detention is necessary. So it is therefore considered essential to prevent you from acting in a manner prejudicial to the provisions of the NDPS Act 1985 by detaining you under the Prevention of So-and-so Act 1988. So well, here, section 3(1) of the Act provides that when the authority, after going through the reports and all, is of the satisfaction, if the authority is satisfied, then under section 3(1) he can pass the order. So the question is subjective satisfaction of the detaining authority here on the basis of the materials available. If Lordship kindly takes up section 3, for a moment. Section 3 provides power to make orders detaining certain persons. 1. The central government or a state government or any officer of the central government not below the rank of joint secretary to the government, specially empowered for the purpose of this section by that government, or any officer of a state government not below the rank of secretary to that government, specially empowered for the purpose of this section or by that government, may, if satisfied, with respect to any person, that with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, it is necessary so to do, make an order directing that such person be detained. So it is the satisfaction of the authority empowered under the Act under section 3, if he is satisfied that the person concerned is to be detained, and his detention is necessary, he can pass an order. So in the detention order grounds, Lordship, I have shown that the bail orders passed by the Honorable Court in the 3 cases mentioned, that has been considered, and after the application of mind in the materials and as well as the bail orders, the authority has come to a satisfaction that his detention is necessary in the larger interest law, and the accordingly order was passed. So this is not a quick case of non-application of mind, as has been pleaded and or as has been considered in the case of Alia Begum, WP Criminal 20/2020, In that case, Lordship has noted, the honorable court has come to a conclusion that the bail orders were not considered. In fact, in paragraph 12, my lord, paragraph 12 of that judgment at page relevant is at page 10. Honorable court has considered, in fact, court has observed that the authority has said that he is in jail, my lord. He was in detention. And the authority did not consider that the particular detainee was already granted bail, my lord. So that is not applicable in this case, my lord. So, I think we're going to give me. Number going to give. Not our. The pleaded case in the writ petition is, my lord, that the husband of the petitioner is innocent. He is not involved in all those offences, and therefore he should be released from the detention. My lord, in respect to that, my lord, my humble submission is, my lord, that it is on the basis of the records placed before the authority, the satisfaction was, my lord, he came to a satisfaction and passed the order. And on this subjective satisfaction of the detaining authority on the materials available before him, my lord, there are decisions of the honorable court, my lord, that it is up to the authority whether the materials on the basis of which, after going through those, he records his subjective satisfaction or not. The original records at this stage, my lord, I don't have. Gotcha. Well, it was listed before the learned single bench, but it was hard and it was made CAV. Ultimately, Lordship has, after that, my lord, Lordship has released the matter because it is to be listed before the division bench. কেতিয়া শুনিছে দাদা? কেতিয়া শুনিছে? দেখো, কেতিয়া শুনিছে? Unlike the other cases, here they have no grievance as regard non-supply of documents and all, my lord.
Not the way we are thinking.
My lord.
We'll tell you why. Number one, according to the petitioner, there are 3 cases. We found out there are 4 cases against him. Both case was never in the knowledge of the authorities. Now, in 3 cases which are there, the order of bail has been passed, but the detention order does not say on which date the bail orders are passed. Because in one case it is in 2021. One case you said the bail order was 11/6/24. One is 23/9/21. One is 27/3/2017.
17.
And one is 5/12/2024. This is the detention order. Now you see, to arrive at a satisfaction that the there is some act on part of the detainee which is prejudicial to the interest of the society. That must be only documented in your record because there is nothing here.
Lordship.
And we don't have any material now to say that the satisfaction, we are not uh, applying our judicial mind on this, whether of sufficiency of the report
Satisfaction of the lordship.
and satisfaction of that is not, we are not going to the decision making, we are not questioning that decision. But decision making process has to be gone into. So that record is absent. That was just one. The second is that if there's nothing on record to show that any act prejudicial to the interest of the society were undertaken, then the order of detention would be interpreted to mean that it is only to frustrate the bail orders. So even there, if there is no material, state fails.
But the detention order, the very first paragraph of the detention order, it reflects the report of the SP on 19/7/2024. It was the requisition from the SP on 19/7/2024. On the basis of that,
We are incapacitated. We don't know what is there in the report. You see, the act must be that his actions are prejudicial to the interest of the society.
lordship.
That means either he is doing that work again or making planning to do that work to enter into the business of illegal trade in narcotic drugs. There must be some materials before the authorities.
So I have to take your lordship in that case to the grounds of detention in the page 18, Malad.
18,
Because page 18.
18
because-
doesn't have that.
Kindly see, Malad, the reference is there, what they have relied, because all documents, Malad, annexure A1, A2, A3, A4, everything has been mentioned. And everything has been given to him, serial number 3. Kindly see serial number 3.
You see, if you are referring to page 18,
Yes, Malad.
please come to paragraph 6.
Paragraph 6, Malad, yes. But before
You
that,
see, these are
before
all past.
before that, kindly come to serial number 3, Malad. Previous
Three.
page, serial number 3.
Yes.
Malad, it appears from the record on that on 10/4/2024 at about 1 PM, information received regarding illegal selling of drugs by you. Information received regarding illegal selling of drugs
That he
by
was
you at
granted bail.
Krishna so and so.
For this, he was granted bail.
Malad, yes, but the FSL report, seizure memo, counterfoil of search sheet, all are the Malad contents of the report. Secondly, serial number 4. So these are the documents, Malad. Those are
These are past history. Paragraph 3, paragraph 4, and paragraph 5,
5,
they are past history,
lordship,
which is referred to in paragraph 6.
lordship.
And in paragraph 6, second paragraph, you see, you have involved yourself. That is past tense.
Malad.
And then at present, paragraph 7,
Yes,
at present, you are not in police remand.
and you have been released on bail.
And your release on bail appears to be seriously detrimental to the large number of people in Gwalpara district. So that means this is an order to frustrate the bail orders. There can be no other interpretation. Your satisfaction is not recorded. That thereafter also there are inputs to show that you are still dealing with the drugs. Because the authorities must be satisfied not for the past, but past actions, but his continuance as a free man would be a nuisance to the society, detrimental to the interest of the society. That is the satisfaction. Where is that satisfaction?
The cases which they have relied, it shows, Malad, from time to time he is involved in those things, Malad. And then ultimately on the basis of that, Malad, the satisfaction will go on.
See, I'll give a simple example. I was a naughty boy in class 5, got 2 cane from my teacher. Class 8, I was still naughty. I get 5 caning in the from my teacher. Doesn't make me a bad boy. Yes, I was naughty then. I got a punishment. I was good enough after that. So he was taken into custody. That's a offense. For that he got bail. Your satisfaction is recorded that because of bail, it is detrimental to the interest of the society. So therefore, the order of bail, the order of detention is based on the order of bail. And that too long after that. This is bail in 21, bail in 2017. And then you say that now it is detrimental.
But the last bail order as has been submitted, Malad,
11/6/24.
on 11/6/24.
So that means after 6 months, you are now making a satisfaction. That you are
Then-
in bail and therefore you are nuisance to the society.
The event, Malad, the language is that even though he's on bail, even though he was released on bail, but his action are, and it shows that he's an habitual.
That is
offender.
past. What is the present? That's why I gave you the
But this
horrible
is-
example of
this-
my getting
this-
caning at
this
class
is the
5 and 8.
Logic, but this is the material, Malad, otherwise, these are the materials considered. These are the materials considered. These are the materials. So my respectful submission as regard the second ground is that there is application of mind, even though orders are there, bail orders are there, Malad, I would submit, Malad, even though bail orders are there, the authority found that his actions are of such a nature that detention is necessary. That is what the satisfaction recorded in the order, Malad. So non-application of mind is not applicable here, Malad. So under these circumstances, Malad, the grounds, detailed grounds have been given, Malad. So under these circumstances, the authority have rightly issued the order, Malad, detention order, detaining the person under section 3, Malad. That is my humble submission.
Please take down. But Mr. R.B. Pukal and counsel for the petitioner, as well as Mr. D. Nath, Leonard, senior government advocate. Along with Mr. N. Kalita, Leonard APP. Leonard government advocate. Government advocate for the state. Next para. By filing this writ petition, under Article 226 of the Constitution of India, the petitioner has assailed the impugned detention order. You said page 15, huh? Order number. It is there in this page 15. Order number so dated 5/12/2024. By virtue of which the empowered authority under, give this full name, PIT NDPS Act, prevention of illicit traffic in narcotic drugs and psychotropic substances Act, 1988, within bracket, hereinafter referred to as PIT NDPS Act for short. Bracket closed. Comma, in exercise of power under section 3 within bracket 1 of the PIT NDPS Act, comma, ordered detention of the petitioner, namely so and so, under PIT NDPS Act till further order. Next para. It may be mentioned that during the pendency of this writ petition, the advisory board under PIT NDPS Act rendered its opinion dated 17/2/2025 comma, recording its satisfaction regarding sufficiency regarding available of sufficient grounds for detention of the petitioner under section 3 within bracket 1 of the PIT NDPS Act. Full stop. During the thereafter, the empowered officer under the PIT NDPS Act, comma, by an order dated 25/2/2025, confirmed the detention order dated 5/12/2024 for a period of 1 year from the date of detention. Next paragraph. Pursuant to notice issued in this writ petition, comma, the state respondent numbers 1 and 2 had filed its affidavit in opposition on 2/6/2025 and justified the issuance of the detention order dated 5/12/2024 and also informing the court about the confirmation of the detention order on 25/2/2025 on the basis of the opinion of the advisory board under PIT NDPS Act dated 17/2/2025. And further pointing out that and further informing the court that the representations submitted by the The representative was by the wife or the husband, the detainee? By the wife. By the wife of the petitioner. Were disposed of by the state government authorities. Oh no. Just say, there is a mistake. The detained person, his name is Zahirul, Johirul, Johirul Islam, ISLAM, and the petitioner is the wife. So here you will write by the petitioner, represented by the petitioner. And in the earlier part of the order, detained person is Johirul Islam. In and in this paragraph 2, you'll have to say that the petitioner has assailed the detention order of her husband, namely Johirul. Petitioner is the wife, he is assailing the detention order of the husband. Next. The learned counsel for the petitioner has made his submissions on the basis of the pleadings made in the writ petition and the affidavit in reply, specifically urging all the points pleaded therein. And supporting the contention that the detention order is vitiated due to delay in disposal of the representations and the fact that the petitioner was on bail, the husband of the petitioner was on bail and did not take any steps which would be prejudicial to the interest of the society. The impugn order of detention is being assailed. Mr. Khan, this how do we deal with the issue that you see what has happened? You have challenged the initial detention order, but subsequent orders of affirming it for a period of 1 year, that is not under challenge.
Yes.
Because the former order would merge again in with the final order, is it not?
Yes. Seventeen to representation and subsequent. Preventive orders.
Because this consequential action,
February 25.
Mr. Fukan, the consequential actions are not on the challenge.
No, man.
But so even if we catch that, the final detention order would still be in force.
Yes, that is fair. These are all subsequents that have happened.
We understand that.
That's the difficulty. This is filed in February.
But that gives you for 2 days more. Technically, okay, what happens is happen. What will happen will
Eventually,
happen.
that's all, my lord.
You
But I
can't do
can-
anything.
But only this, if I permitted one aspect, Malad, just to add, Malad, that there is an opportunity for the authorities to explain the delay if in a given case, Malad. This is 2009 3 GLR 740
February key.
division bench of the Senate.
February की नजर।
1000,
2009 3 GLR 740
74,
740
740.
750. It's a small judgment, Malad. Para 6, there was 222 days delay. It was dismissed, but the Honorable Court has said that it is a settled position of law that a representation submitted by detainee is required to be expeditiously disposed of in accordance with the provisions of the article so and so. And the competent authority, the same has to be satisfactorily explained with cogent reason. If there is delay, that has to be explained by cogent reason. Only to that extent, Malad. That there is an window, there is an opportunity for the authority to explain the delay. In that case, it was not explained. 222 days delay. Malad.
or 9,
2009
9.
2009 3 GLR 740 Dibakar Moran versus Union of India.
Yes, the Bhakar Mora.
Dibakar Moran. Para 6, Malad. 740.
No, this would be a reading out of context. Reason is, we'll read that paragraph. It
Lost.
says it's a settled position of law that a representation submitted
Malad.
by a detainee is required to be explicitly disposed of in accordance with the provisions of Article 22(5) of the Constitution of India, read with provision of National Security Act. If there is any delay in disposal of the representation by the competent authority, the same has to be satisfactorily explained with cogent reason.
Malad.
The instant case is a classic case of delay of 220 days, 222 days in disposal of the representation, that too without giving any reason.
Okay.
So therefore, that cannot be coming to your aid.
My,
When the earlier constitution judgment says, and our other judgment says that the delay of 5 days also is fatal.
my respectful submission is that scope of explanation of delay. Scope for explanation of delay. There is a scope for the authority to explain the delay, if there is something.
You see, that doesn't help you for any reason. The reason being, number one, that we refer to the other constitution-based judgment, where the delay was held to be fatal. So therefore,
There is no explanation in that case.
there is no explanation. in
There is
that.
no explanation. Matlab,
Doesn't help you. You have made a point, but doesn't help you.
So the respectful submission is that there is scope is there for the authority to explain if some delay has occurred. The reason has to be placed before the honorable court, and that can be done. It is not a case that there is no straitjacket formula that within 7 days it has to be done, within 4 days it has to be done. If the reason is there, it can go beyond 10 days, beyond 15 days, beyond, it can go.
Next. Per contract, the learned senior government advocate has submitted that the that after the representation of the petitioner was received on behalf of her detained husband, comma, the advisory board was in session of the matter relating to the preventive detention order of the husband of the petitioner. And its first sitting was held on 20 January 2025. And accordingly, all the records relevant to the case were requisitioned, and the authorities had produced all the relevant records before the said advisory board. And the advisory board gave its opinion on 17 to 2025, justifying the detention order. And subsequently on 25 to 2025, the confirmation order was passed by the competent authority. Stop. Accordingly, it is submitted that where is where is that rejection order of the
Annexa A, page 68,
page
68,
58,
68, madam. 68,
68?
68.
The 10-4.
10-4.
Accordingly, the state has an explanation for the delay that occurred in disposal of the representation dated 8/1/2025 by the petitioner, by an order dated 10/4/2025, passed by the competent authority. Full stop. It is further submitted that the bail granted to the petitioner that though bail was granted to the petitioner, but his actions in repeated indulging in repeated offense relating to trafficking of drugs and narcotic substances was found to be prejudicial to the interest of the youth of the society and the district of Gwalpara in particular, and therefore the detention order was fully justified. So in that previous paragraph, there is 4 cases cited. Huh? This 4 is by petitioner. I like P here. Just add that in the submissions of Mr. Speak into serial order P1, 2, 3, 4. Huh? So the petitioner is relied on so and so, the learned senior government advocate has placed reliance on a decision of this court in the case of Dibakar Moran, Dibakar Moran, alias Rabin, Rabin, Barua, Baruh, alias Dharmeshwar, Dharmeswar, Deori, Deori versus Union of India and others, comma, within bracket 2009, bracket post 3 GLR 740. Next, in this case, the detention order dated 5/12/2024 has been challenged before this court. Full stop. During the pendency of this writ petition, the competent authority has passed an order dated 25/2/2025, thereby confirming the detention order for a period of 1 year from the date of detention. Therefore, the question would arise as to whether the confirmation of detention order which was passed on accepting the report of the advisory board would be can be held to be invalid merely because of two grounds urged by the learned counsel for the petitioner, 2 out of 3 grounds urged by the learned counsel for the petitioner. Firstly, that the detention order is invalid on the ground of delay in disposal of the representation. And secondly, whether the non-assailing of the order of confirmation would negate the nature of challenge made in the writ petition. Next one. In this case, the advisory board had given its report, given its opinion on 17/2/2025, which is within a period of 3 months from the order of detention. Therefore, in the present case in hand, we find that there is due compliance of clause 5 of Article 22 of the Constitution of India, clause 4 of Article 22 of Constitution of India, as the matter was referred to the advisory board, and only thereafter the extension orders were passed. Actually, confirmation orders were passed. Next paragraph. Under clause 5 of Article 22 of the Constitution of India, any person who is detained in pursuance of an order made under any law providing for preventive detention, the detained person is seen to have 2 rights. Firstly, that the authority making the order shall, comma, as soon as may be, comma, communicate to such person the grounds on which the order has been made. And comma, and secondly, comma, the detained person shall be given an opportunity at the earliest of making representation against the order. Full stop. In this case, there is due compliance of clause 5 of Article 22 of the Constitution of India. We'll continue post lunch.
Sure.
Regard item number 9, you got to fix a date for another two.
I'll just tell the court master. You give your day convenience, we'll fix it on that day. Tell it to the court master.
Convenient data.
Uh, Where is that observation that delay of that 7 days also were there?
In that judgment, my.
No. In the order, the reference to the representation,
Yes,
it was forwarded
yes,
on a
ma'am.
particular
That-
date and 15th
yes,
was it.
that
Where
is,
that?
That is an annexure A of the affidavit filed by the government. Page 68, I think, might not be your.
Ah, yes, 15-1. Thanks. Next para. Insofar as the delay in disposal of the representation is concerned, there is no legal mandate about the number of days within which a representation should be disposed of. Stop. However, in the case of Dibakar Moran, alias Revin Bora, alias Dharmeshwar Deori, within bracket Supra, the court has observed that, this court has observed that the delay, unless explained by the authorities, would be a relevant factor. Full stop. This court, in the case of Rongjam, RONGJAM, Momin versus Union of India and others, within, comma, 2005, within bracket 1, bracket was GLT 173, has held that mere unexplained delay of 7 days in forwarding representation would be fatal. Stop. In the present case in hand, on a perusal of the order dated 10/4/2025, passed by the competent authority, thereby rejecting the representation submitted by the petitioner on 8/1/2025, there's a reference that the representation dated 8/1/2025, submitted by the petitioner was forwarded by the superintendent of district jail, Gwalpara, by letter number capital GLPJ full stop 31/2025/53 dated 15/1/2025. However, there's no record of any explanation of the delay why the representation was not forwarded with utmost urgency. And in this case also, the delay of 7 days in forwarding the representation remains not explained. Next paragraph. In the case of Jay Narayan, JAYANARAYAN, Sukul, SUKUL versus State of West Bengal, within bracket 1970, bracket close 1 SCC 219. The Constitution Bench of the Supreme Court of India had laid down 4 principles which should govern the consideration of representation of the detainees. Full stop. This paragraph 20 has to be quoted. You put paragraph 19 and 20. Paragraph 19 and 20. The above is quoted below. Next paragraph. From the hearing before quoted paragraph 20 of the case of Jayanarayan Sukul, within bracket Supra, it is noted that the representation of the consideration of the representation of the detainee by the appropriate authority is independent of any action by the advisory board. Full stop. In the present case in hand, the competent authorities in the state government authority in the state government while rejecting the representation dated 10/4/2025, sorry, on 10/4/2025, appears to have waited till the report of the advisory, till the opinion of the advisory board was pronounced. Therefore, it appears that the competent authority did not independently exercise its mind on the representation, which appears to be the requirement of law as laid down by the Supreme Court of India in the case of Jayanarayan Sukul within bracket Supra. Next. Therefore, in the present case in hand, the delay in forwarding of the representation dated 8/1/2025 on 15/1/2025 after a lapse of 7 days on part of the Superintendent of District Jail, Gwalpara, which is not accompanied by any material on record to explain the delay in forwarding the said representation. Is not found sustainable. To stop. Next paragraph. Moreover, the competent authority in the government of Assam, while rejecting the representation by an order dated 10/4/2025, it's found to have not taken up the issue with utmost urgency and deferred its decision-making process till the advisory board give its opinion. And the said delay is also found to be fatal. Next, accordingly, on these two counts, the impugned order of detention dated 5/12/2024 is liable to be interfered with. On the ground that the detaining authority while issuing the order of preventive detention did not follow the rigors attached to the conditions of exercise for the said power. Next para. Moreover, in the impugned detention order dated 5/12/2024, though there is a reference to three cases against the husband of the petitioner for dealing with narcotic drugs and psychotropic substances are referred, being Krishnai PS case number 30 of 2024, Krishnai KRISHNAI PS case number 30 of 2024 under section 21 within bracket small b oblique 29 of NDPS Act, number 2, Lakhipur, LAKHIPUR, Lakhipur PS case number 292 oblique 2017 under section 21 within bracket small c of the NDPS Act, and number 3, Lakhipur, LAKHIPUR, Lakhipur PS case number 296 of 2021 under section 22 within bracket C of the NDPS Act of the 489B IPC are referred to, but in course of submissions, the learned counsel for the petitioner has submitted that that in connection with Krishna PS case number 30 of 2024, bail was granted on this first case, Krishna PS
11/6/2024.
11/6/2024, bail in Lakhipur PS case number 292 of 2017 was passed on
23/9/2021.
Yes, and bail order in Lakhipur PS case number 296 of 2021 was passed by this court from 27/3/2017. To stop. The impugn order of detention dated 5/12/2024 does not refer to any subsequent act on part of the petitioner which required his preventive detention is recorded in the said order. And in the grounds of arrest, which is accompanying the detention order dated 5/12/2024, there is a reference to the fact that the petitioner was not under police remand and was released on bail. So accordingly, in the absence of any act on part of the petitioner to deal with illegal trafficking to deal or traffic in narcotic drugs and psychotropic substances, it appears that the detention order was passed to overcome the grant of bail by the court having jurisdiction. Next. In view of above, the court finds that the impugn order of detention dated 4/12/2024 is again not sustainable. Next paragraph. In view of the discussions above, comma, the court does not consider it to be necessary to go into other points raised by the learned counsel for the petitioner. For the reasons outlined above, comma, the detention order number so and so, page 15, dated 5/12/2024, stands, is found to have been vitiated. And accordingly, this writ petition deserves to be and is accordingly allowed. The as a result, comma, the said impugned order dated 5/12/2024 is hereby set aside and quashed. Next. Next paragraph. It is needless to say that the constitutional order this is at page 82, like. This is at page 82, huh? 82, like. Is the e-file number dated 22, 25 to 2025. Issued by the competent authority, or thereby extending the period of detention for 1 year from the date of detention. Would not come in the way of the state to release the petitioner. On the question of the detention order. Full stop. The detainee, namely so-and-so, is directed to be set at liberty, comma, if not otherwise wanted in any other case. We are adjourning other matters because we are taking up this single bench matter. Sir, just before that, last say that the points of determination framed herein before are answered accordingly. We have framed 2 questions. So you see the points of determination as framed herein before. The 2 points of determination framed herein before are answered accordingly. We passed the order to the effect that the tribunals can take help of the Office of the Superintendent of Police to get the records scanned and sent. But there was some bottleneck. We won't like to address it here. But there were bottlenecks for which it couldn't be done. So at least the Cat6 cables will have to be laid down. It has to be made user friendly for video conferencing, and those things are number 1. The others, the tribunals are in the rented houses, most of them. They don't have urinals. They don't have what you call separate urinals for the proceedings or their family members who come. Now the Supreme Court has given a requirement that every courtroom will have to have certain amenities, which includes baby room.
Yeah.
Sorry, which is called childcare rooms.
Right.
So all these infrastructures, there are long list of requirements, which is already addressed in the last year, the previous sitting. You can interact with the PWD is there. Can you tell us how do you propose to meet the infrastructure requirement of the foreigners tribunals?
We both Chief Engineer, myself, and Joint Secretary is here.
Yes.
We have, as per last order, we have sit with the Home Department Secretary, and accordingly, we are our viewers are total 100 numbers of FTs in all over Assam, and out of that, 44 is in private building and 56 is in government building. So in the last record, what we have received from field office, in Kachar, we have received a request for 6 numbers of FTs for upgradation and improvement of sanitary system. And that is what it was in 2023. So at that time, the estimate were submitted, but we didn't receive the administrative approval at that time. And in case of Borpeta also, estimate were submitted in 2022. And at present, we have Udalguri.
Who
FT.
who is the authority to give you this administrative approvals?
Home Department. We have already discussed. So at present, one FT at Udalguri that is costing about 24 lakhs. That is a tender process is on. And Kamrup Metro, we have 5 numbers of FT and 3 estimates were submitted. For first FT, we have submitted 8 lakhs. For second and third FT, 6.82 lakhs, and fourth and fifth FT together 9.71 lakhs. So the all 3 estimates were submitted. AA is yet to be received. So that is our present position. And for upcoming,
you see, you are from PWD. You can present data and statistics in a manner which sounds good, but you please understand that we want an effective building, correct? Your stage of proposal, the budgetary allocations, the what you call the sanctions, the administrative approvals, they do not carry any meaning unless the infrastructure is seen at the site.
yes,
That's number one.
yes.
Number two, you see the delay in this in the creation of infrastructure.
Yeah.
It affects the capability of working of an officer. Let us think of a situation where you are the secretary of PWD or a chief engineer of PWD. You are given a ramshackle office with very untidy desk. Your secretaries are about in 2 rooms after you, and this is the environment you are getting. No AC, no record room. Your files are stacked in the floor. As an administrative head of your department, will you like it?
No, sir.
Will the government get efficiency from you if the infrastructure is not given, an appropriate infrastructure is not given? So you see, the requirement is not only of a good infrastructure, it must also be good for the working of the presiding officer there. If I give you a very, very wonderful room, but it is not convenient for you to work. Correct?
Yes,
Yeah,
sir.
yeah.
So a wonderful room doesn't help you. You must get a, that is why Normally what you do is that you ask the user as to what is their requirement. If it is in my court, I will need, for example, say the law books. In my front, I have few law books which are accessible to me by hand. So it is convenient to me. For some other honorable judge, maybe the books are stacked with the court master so that it is convenient for the court master to bring out the book and give it to us. So every authority which is in a administrative capacity has its own requirement, special requirement. The requirement of the Joint Secretary PWD may be different from the Chief Engineer building. Correct. So
Correct.
therefore, you'll have to first have a consultation with what is actually required and then make it happen. That's because the delay which is occurring in creation of the infrastructure is not healthy for the state because these tribunals are dealing with people who have doubtful citizenship.
Yes, sir.
So it is in the interest of the state that these matters are decided at the earliest. Now, because of the lack of infrastructure, we are still having cases where the references are of the year 1998.
Yes.
1998 and today we are 27 years down the line and the reference given by the Superintendent of Police creating a doubt on the nationality of a citizen, of a person, is still not being adjudicated. That is why the Supreme Court has given a mandate to have a monitoring bench for expeditious disposal of these cases. It is the requirement of the state. Please don't think that the High Court wants a lavish building for the tribunals. It's not that. It is for the requirement of the state. State wants to expel people who have doubtful citizenship. So you'll have to impress upon the government that this is not something, you see, the Foreigners Tribunal is not working under the High Court administratively. It is working under the Home Department.
Yes, sir.
So it is this requirement of the state. So you'll have to see it in that aspect.
Right.
This is not a building which is housing any judicial complex for the district judiciary.
We were informed by Home Department that they have already listed about 33 items of requirement. So that has been distributed to all FTs, and based on that requirement, they will be informing our PWD, and accordingly we will prepare the estimate.
But you see, even small things like table and chairs are not there. The officers tell us that small things, they purchase it from out of their own salary.
Basic amenities are not there.
Basic amenities, things for basic amenities are being purchased by them. Even small things like cushion for a chair. These are not provided for. The officer has to sit in the chair and therefore he purchases a small cushion for the chair from her own pocket, his or her own pocket. These requirements, where are those requirements those which were penned down?
My lord,
Yeah.
Lordship may kindly have a look at the order dated 2nd of September 2025.
2nd of September 2025.
Right. In fact, the first order in which your lordship has passed an effective order of the requirement to improve the infrastructure manner,
Yes,
your lordship specifically directed certain things to be done.
yes.
That is reflected in order dated 2/9/2025.
Infrastructure status, page 3 of the communication in table 1, apart from 26 listed items,
Yes, one more item.
other essential requirements, Courtroom with Ajlas,
Yes,
chamber for the foreigners tribunal members, space for the assistant government pleader,
my lord.
record room are required to be added. So 4 things were required to be added.
My lord, may now kindly take up the instructions that we placed on record before your lordship on 3rd of 11/2025.
Third, 3,
3
11, 20.
11/2020. It came from Home Department,
3,
3/11/2025.
just find out 3, 11, 2025. ये अपने पते हैं।
কোনো প্রথম ভালকে দেখবে লাগে তো
Yes, 3, 11, 25. Yes, you got it.
Yes, now my lord, second page, lordship, this was the response from the Home Department on
Yes.
3/11/2025. There, my lord, after your lordship passed an order for modification of that format,
Yes,
a revised format was according to them. This was issued by the Home Department, my lord.
yes.
Now, in this, your lordship will find that all these were added in the first, my lord, column. It has been mentioned that in response, in respect of the issue of adequate infrastructure facilities for the foreigners tribunals in the state of Assam, learned AAG
You're
has
in which page of this
fir-
comparison?
first page, second page. Second page, there are two columns. I'm reading
Yes.
for the first column.
Requirement, courtroom with Ejlas.
Yes, yes,
Member-
ma'am.
Members of foreigners tribunal.
Yes, ma'am. So these are the infrastructure issues which are to be addressed as per your lordship's direction.
Yes.
The Home Department, Mr. Sorgieri, I think is there. Lordship may kindly take the response as to what is the present status of this one. বুঝছে না? হুম? আজকে নয় মনে হবে না রাখে ভাবতে পারবে।
But this is limited to that infrastructure
My lord. So,
of Silchar.
no, this is with regard to the infrastructure for all the courtrooms. Courtroom with Ejlas, then chamber for the foreign tribunal
No,
members.
here is the
spe-
heading says Annexure A. Infrastructure status of foreigners tribunal, second Silchar.
That there is a separate issue with regard to Silchar, ma'am. I'll come to that.
Okay.
So far as the, in general, for all the foreign tribunals are concerned,
Hmm.
pursuant to your lordship's direction of 2nd September, my lord, some modification was made in the format through which they have to take response from the individual foreigners tribunals, and in the right hand side, the action taken report, the lordship is.
Please show us a copy.
What could it can be? And my land press copy of it can be used.
Yep, I do. Yep, fine.
Lordship may kindly use my learned press copy for the time. Serially
Yes. Okay, we are ready not getting it. Ah, yes, but we have seen this.
Yeah. Now, there, as your lordship has seen, in this replies to directions dated 2/9/2025.
Hmm.
So from the Home Department, this was the response. They say format was issued. Apart from 26 listed items, 4 more items were added,
Yes,
where your lordship directed that even the court route Ejlas is not there.
yes.
So with regard to this, what is the present status, my lord? I think the officers are present before lordship. They may apprise this honorable court as to what is the present status of this. Because the lordship ultimate direction is to, my lord, possibly improve the infrastructure of the courtrooms with all these amenities as a
Yeah.
whole,
As a whole
in respect of all the foreigners tribunal.
of the project.
And your lordship's direction that what is the proposal as to how the infrastructure requirement of the foreigners tribunal would be met is in respect of all the foreigners tribunal.
Yes.
So there, my lord, what is the position lordship may kindly take the response from them so that it is clear.
Okay. You see, while assisting us, the learned Additional Advocate General has referred to the letter by the Joint Secretary of the Government of Assam, Political B Department. This is a communication by the said department to the Additional Advocate General. This is dated 3/11/2025.
My lord.
Signatory is Nivedita Goswami. Now, she has, in this letter, referred to the infrastructure requirement in response to the court order dated 2/9/2025 and the action taken report. Now, in this report, action taken report, it has been mentioned that the revised format was circulated to all the deputy commissioners and replies are received only from Dhubri, South Salmara, Tinsukia. And there's incomplete report from one district, 5 reports are in the previous format. Then
Next issue is 2C is in respect of those, my lord,
2C is Silchar,
Kachar,
2C is
FT.
Silchar.
yes, 1 to 6 Silchar.
Now, in this, the special commissioner was requested of the PWD building was requested to take necessary action. This is with regard to the Foreigners Tribunal First Kachar. Says lack of lavatory facility. What do you say of this for the PWD? What do you have to say on this? Silchar Foreigners
yes.
Tribunal number 1, 2, 3, 4, 5, and 6.
We have already received the requirement from the 6 FTs.
Yes.
First to 6. So it is, we have collected it on 17th of November. So the necessary estimate will be prepared. In the revised format.
Okay. Then you just write. We'll formulate the order later on,
Well-
just dictating whatever has happened. I heard Mr. H.K. Das, was training counsel for the High Court, Mr. A. Das, done an amicus curiae, and Mr. D. Mazumdar, done Additional Advocate General for the state, assisted by Ms. D. Devi and Ms. L. Devi, learned counsel appearing on behalf of Mr. R.K.D. Chaudhary, learned DSGI, for the Union of India. Next para. On a court query with regard to the communication dated 3/11/2025 by the Joint Secretary to the Government of Assam, political within bracket B, bracket close department. Which contains the infrastructure requirement and the action taken report, comma. Mr. Kindly give your name so that I can record it.
I believe Mr. Divakar Sorgiari from the Home Department. Am I
Mr.
correct?
Divakar Sorgiari.
And let us confirm it. I don't
Huh.
know him
Oh,
personally.
okay, please give your name, both of you, please.
Myself, Joel Timung, Chief Engineer, PWD. And
Please give the spelling, we may make a mistake.
JEWEL.
Joel,
Jewel
yes.
Timung, Timung. Correct?
Timung, okay,
Yeah.
TIMUNG,
Chief Engineer Building.
Chief Engineer Building,
PWD.
Yes.
comma,
And
PWD.
myself, Sri Rahul Dev Basumutari.
Oh man.
Rahul
Rahul Dev Basumatari.
De,
Right,
Rahul Dev.
DB,
Correct? Rahul Dev Basumatari.
right, sir.
Dev Basumatari.
Right.
Joint Secretary.
Basumatari you spell as BASUMATARY.
Right, sir. BASUMATARY.
Okay, Basumatari.
Your designation, please.
Your designation?
Joint Secretary, PWD Building.
Okay,
And
Joint
NH.
Secretary, PWD Building. Have
Hmm?
submitted that
Funny.
in respect of
Oh.
infrastructure at column A, comma, the
Oh. Oh, okay. PWD.
necessary inputs have been received in the new format, which includes 4 additional items which are mentioned in the order dated 2/9/2025. Full stop. It is submitted that the said proposals were received only on 17/11/2025. 17/11, right?
Right, sir.
17/11/2025. And estimates and budgets are being prepared
Underprepared.
to be sent to the competent authority for approval and sanction. Full stop. Next para. In this regard, comma, on the next date of listing, comma, the PWD within bracket building, bracket to Assam, shall inform the court in writing about the steps taken so far is regard to item A of serial number 2 of serial number 2 regarding infrastructure and the action taken report. Next para. In respect of item at serial number C of serial number 2,
2C.
2C, make it 2C. 2C,
In
of the
respect
said
of
communication dated 3/11/2025.
FT.
Yes, in regard to Silchar, what do you say? With regard to Silchar, what do you have to say? 1, 2, 3, 4, 5, 6. Yes, with regard to Silchar tribunals, 6 Silchar tribunals, what do you have to say?
To us, PWD.
Yes. PWD, what do you have to say?
That in new format, we have collected the information on 17th.
Okay, same. But then you cover A and B together. A, C, 2A, 2C. And then we have 2D with regard to the repairing and renovation of sanitation work in Foreigners Tribunal. Here, the learned member of the Foreigners Tribunal was had given an order to the contractor to take up some additional works. And the matter was taken up with the PWD building authorities. What do you have to say with regard to this for additional work at the Foreigners Tribunal at Silchar?
It will depend upon the nature of work. That will be, if it is fall under PWD, then it will be incorporated in the estimate.
Okay, two D also same.
Well, may I just indicate?
Yes.
In this manner, 2A, somehow D is not there. They have taken from A to C, they have written. Anyway, this C, D, and E, if your lordship reads together, my lord,
Huh.
what transpires is that, my lord, there are two issues here.
Yes.
One is specifically about the renovation of laboratory facilities in FT1,
Yes.
and the other is in respect of repairing and renovation of sanitary system in Coordination Tribunal 1, 2, 3, 4, 5, 6.
Yes.
So these two
Which
issues were
include
taken
additional
up. Your
work.
lordship passed an order because earlier we gave an indication that everything is over, it is completed. But
Yes.
subsequently it was found that nothing was done because some letters have come from them. Thereafter, your lordship, if your lordship goes to third page to E,
Yes.
there your lordship has indicated, it's a summary of what your lordship indicated actually in the order. It says, accordingly, the court is inclined to direct the chief engineer of PWD building or any officer under him to produce a copy of the plan and estimate relating to the repairing and renovation of sanitary system works in the Foreigners Tribunal 1, 2, 3, 4, 5, and 6 Kachar, and to also inform the court regarding the projection that the learned members, Foreigners Tribunal 2nd Kachar, had ordered the contractor to take some more works in addition to the works mentioned in the estimate. Let the relevant communication be produced. Moreover, responsible officer of the PWD Buildings Division shall inform in writing as to whether the repair and renovation works of sanitary system in Foreigners Tribunal 1, 2, 3, 4, 5, and 6 in Kachar has been or not yet been completed as per already approved plan and estimates. So here you will kindly take the response from them
Okay.
since they are online.
Yes. Earlier, your communication said that the tribunal works are over, but we found out that no works were done. Renovation of sanitary system works of tribunal 1, 2, 3, 4, 5, 6, which is point number E of that communication dated 3/11/2025.
Actually, the earlier the estimate were submitted, but AE were not received. Administrative approval were not received. So work could not be initiated.
No. Then you see, because earlier the reflection was that the works were done.
Actually, what happened in 2023, at that time, ADC from the DC office in Kachar communicate to that executive engineer at that time that to prepare estimate. The executive engineer had prepared estimate and submitted in the year November 2023 itself, 2023 itself. The estimate was prepared, but I don't know whether the work has been executed through through other department or not. So, but it was not definitely through PWD, not done by PWD. PWD prepared the estimate and submitted.
No. Because in this case, what had happened was the
Second September 25 order
as per
will
instructions given by letter number PLB 28967/1479 issued by the Joint Secretary to the Government of Assam. I think this is Public Works Department. Just can you have that letter?
yes, my lord. Letter.
Huh.
I'm your lordship is referring to the letter dated 29/5, my lord. 29/8/25.
This is paragraph D, 2D of the order dated 2/9/2025.
My lord, yes, 1479.
Yes,
Yes,
this is by the Joint Secretary. Which department? I think we forgot to
yes,
record.
it is quoted from that letter.
Yes.
Number 28967. The file number 014.
So that, you have that, the letter, that. Because that is by the PWD stating that the infrastructure has been completed. And then we found out it's not done.
Yeah.
They said that some more requirements were placed and pursuant to that, your lordship was pleased to the order. Para E. EFT.
No, first is D. This is the
Yes.
letter we are wanting.
Yes.
DE here somehow your lordship has quoted the letter of the government.
But the
that letter
department,
they
no,
said
which
that-
department we did not quote? Yes. E. Mistakenly that. Forgot. Forgot to have it. But since normally this is a letter by the joint secretary, we expect that it would be from the PWD, no one else.
Yeah.
You see, we'll tell you, we have forgotten to written the name of the authority who's given that letter. That letter number is PLB 28967. Please note it down. PLB full stop 28967 oblique 1479. This is issued by the Joint Secretary of the Government of Assam.
My lord, it is-
Perhaps it is from PWD. And here it says, in this regard, Additional Deputy Commissioner Kachhar
I've got the copy.
has informed by so and so that the repairing and renovation work of sanitation has already completed as per plan and estimate. But the foreigners member ordered certain extra works which is not to be, which was not done, but we found out that
Okay.
works were not done.
Letter be like. There is the letter, my lord. It has to be from the home only.
From
because
the Home
P-
Department.
PLB is the initial Q.
This is signed by Jayanta Kumar Bora. And e-signature is of 8/6/2024. And therefore, we required you to respond as to whether these sanitary works were done or not done. Because if now you are taking a stand that the works and estimate are being are being pursued, that means your earlier instructions were wrong and would be a false statement before the court. It will have various consequences.
Serious consequence.
You understand the gravity?
Right, sir. Right.
So this business of this plan and estimates has to be brought to a notice, because you see, for your convenience, we have relaxed the rules for filing of an affidavit so that you truthfully come out with all the relevant facts and it is easier for even you. But if letters of this sort are coming with contradictory information, then we'll have to direct each of you to file an affidavit. It will be not only cumbersome, but it will delay the infrastructure requirement of the foreigners tribunals. So, referring to this 1479, you please ensure that within a week from today, you instruct your additional advocate general about the infrastructure requirement of the Silchar. within a week. This is that E is concerned. No, D and E. You say that the Joint Secretary to the Government of Assam, PWD within bracket building, and the Chief Engineer within bracket building, PWD, Government of Assam, who are appearing online, shall provide written instructions to the learned Additional Advocate General about the status of the works
Repairing
referred
and
to
renovation of
at
sanitary system.
serial number D and E of paragraph 2 appended to the communication dated 3/11/2025 of letter number PLB full stop 28967/1863 issued by the Joint Secretary to the Government of Assam, political within bracket B bracket post department. Now, we'll then issue a direction that on the next date of listing, the matters will be listed on 2nd of, no, this is 2nd will be not there.
It's reopening on 5th, I think.
5th, it will be
Fifth.
opening on 5th.
My lord.
5th or 6th. Whatever.
So 6th of
6th, perhaps, Tuesday.
Tuesday.
Yes.
So on 6th of January, you will be required to produce all the records relating to the communications and the receipt of the all communication relating to the infrastructure requirement, including plan and estimates. You produce it through the Additional Advocate General on the next date of listing. Within a week, you communicate to him so that he can acquaint himself with the facts so as to assist the court. And so far as PWD is concerned, you will have to bring all the records relating to the infrastructure in all the foreigners traveling in Assam, including communications made with various authorities.
Since your lordship is fixing it on 6th, let them have 2 weeks so that they can comfortably do it.
Hmm?
Let them have 2 weeks instead of 1 week, because lordship is fixing on 6th, so by that time
Okay.
I'll have an.
Okay, 2 weeks' time.
You have 2
Additional
weeks
Advocate
time.
General is paying for, so we are granting 2 weeks' time to you to acquaint him with all the documents.
That should be all right, I think. 2 weeks time.
Yes, Additional Advocate General is asking you, both of you,
They are somehow not audible.
2 weeks' time is adequate to you?
Yes, for that Kachar.
Yes, okay.
For Kasar, it is, yes.
For Kachar.
Yes, to meet the Additional Advocate General and to give him some documents and then have his instructions. The production in the court will be on 6th of January 2026.
But may I just make one submission? Since till now we have jotted down the items which are the requirements of the court, tribunal, for an stability. And this order was passed also, my lord, sometime in the month of September. Now, they have also said that they have received the items, my lord, of all the tribunals. Now, instead of, my lord, the things should not get delayed because of this administrative approval, that plan and estimate. Because since we have received the item, whatever they want to do, that
No, because they,
plan
you
and
see,
estimate,
being
budget
a
and-
part of the government, they'll have to have plan and budget, and then only after sanction, they will have to do it.
Procedure, whatever procedure you follow, but do it expeditiously so that the things can be put in play. By the next day, on 6th, your lordship has fixed the matter. Let them bring all the records pertaining to the requirements, how much the budget received.
Yes, that's what we are doing.
Yes, my lord,
That's
that
what
is
we are doing.
all
And we'll
for
ask
all
the
tribunals.
presence of the Home Department also.
My lord, in fact, I'll pray before your lordship, to, it will be a little bit inconvenient for the officers because let them come up once, Home Department as well as the PWD building with the records before this court on 6th. Let us have a, healthy discussion on that day, how we can improve the functioning of the tribunal.
Okay.
And just one more thing, my lord, from the order passed by your lordship on 2nd of September and the subsequent order passed this instruction, what it appears to me, my lord, there are three major issues so that lordship may every time direct the officers, lordship can direct that in respect to each number. Three major issues. One is the overall infrastructure of the tribunal. Second is specifically Silchar 1 to 6 FT. And third is, in this instruction, lordship will find tribunal of one district functioning from another district. These are the
yes.
three major issues.
Three major issues.
So in respect of that, your lordship will call for the response from the department. So that every time your lordship takes up the matter, lordship can specifically go to the issue as to what has happened to this issue.
Okay.
Second is SOP. Third, there are four, my lord. First
SOP.
is infrastructure. Second is the tribunals in FT. Third is SOP. SOP will cover all the procedures, review petition, how to be dealt with, then the court fee, etc. And then lastly, that district, one FT functioning from another place.
Yes, you are absolutely right.
Well,
But there are, apart from these issues, key issues are all the data is received. But I just want to place these. One is with regard to the infrastructure of Dibrugarh Coordinate Tribunal 2, the fire broke down and the condition of infrastructure is not good. So they are paying for shifting to another place and do the renovation work.
Okay. Yes, PWD, this is also a serious issue. The Foreigners Tribunal Dibrugarh 2nd was burned on 8/4/2025 and does not have an infrastructure. It completely destroyed the electrical wirings, and the tribunal says that they are working at a risk. So you'll have to make arrangement for their shifting if you don't repair that. And this is to be taken up urgently. Acha, this infrastructure issues, what we gave the dictation earlier, you modify it to the effect that the first is heard so and so. Second is also heard so and so who are appearing the Joint Secretary PWD and the Chief Engineer Building PWD appeared through video conferencing. Next para, the office, the Joint Secretary to the Government of Assam, PWD, and the Chief Engineer Building PWD have submitted that they have received the infrastructure requirements from all the tribunals, including the foreigners tribunals at Silchar.
Not all,
Not all, sir.
only 6.
Silchar number 1 to 6.
Yes,
Only Silchar.
only
Yes.
Silchar, 1 to 6.
And
1 to 6.
others,
The rest will be received through Home Department.
Okay. Only 6.
Only 6 we have received.
Only received the infrastructure requirement of only foreigners tribunal 6 Silchar.
Yes, from 6.
The infrastructure requirement of all of the foreigners tribunals would be received through the
Home Department.
Home and Political within bracket B department, correct?
yes, sir.
Yes.
Next paragraph. Accordingly, the court is inclined to direct the Public Works Department within bracket building, Government of Assam to ensure that all relevant instructions with regard to the infrastructure, including communications for having the plan and budget estimates prepared and sanctioned, approved oblique sanctioned, be placed before the Additional Advocate General for the state for his perusal, so as to enable him to assist the court when the matter is taken up next. Next para, the said authorities of the PWD shall also ensure that copies of all communication is produced before the court on the next date of listing. Full stop. The State Public Works Department within bracket Government of Assam, not bracket, comma, Government of Assam shall ensure that the PWD is represented by an officer not below the rank of Joint Secretary to the Government of Assam, and the Chief Engineer, comma, PWD within bracket building, or their respective delegate. No, for the Chief Engineer or his delegate to be physically present on the next date of listing with all the relevant records relating to infrastructure of the foreigners tribunals. No, this will come later. Next para. As the infrastructure requirements is stated to be routed through the Home and Political within bracket B department, comma, the court is further inclined to direct the Home and Political within bracket B department to ensure that an officer not below the rank of Joint Secretary to the Government of Assam, comma, Home and Political within bracket border bracket department is also physically present on the next date of listing. Next para, the order for personal appearance of the officers have occasion because of the fact that for the infrastructure issues is pending before this court since the passing of the order dated 1/8/2025. And if the issues are not taken up in the right earnest, comma, there is every possibility that after the lapse of the month of March, comma, no funds would be immediately forthcoming for meeting the infrastructure issues of the foreigners tribunals in the state of Assam, which is grappling with the inadequate infrastructure issues. Next para. The registrar within bracket judicial of this court is in receipt of communication dated 6/11/2025 written by the learned member, comma, foreigners tribunal, Dibrugarh second, to the Secretary of the Government of Assam, Home and Political within bracket B department,
My lord,
informing,
excuse me for another court. My lord.
yes, informing that the working condition in the said foreigners tribunal is very poor and unsafe. And after a fire which had occurred on 8/4/2025, comma, electrical wirings and other assets in the said tribunal was destroyed, forcing the members and the staff of the foreigners tribunal to function together in one room, which is used for the courtroom, office, the chamber of the members, and also the working place for the staff. Full stop. The prayer made in the said letter dated 6/11/2025 is to shift the tribunal to a safe accommodation, safe and adequate accommodation. Full stop. The said issue is brought to the notice of the state PWD within bracket building, and also to the home and political within bracket B department. Next para, the registrar within bracket judicial of this court is also in receipt of a letter dated 1/12/2025 by the Northeastern Law House regarding renewal of subscription of GLT for the year 2020 to 2024 and supplement volumes for all foreigners tribunals. Full stop. Let a copy of the said letter be provided to the Additional Advocate General for the state for consideration by the Home and Political within bracket B department. Next para. This dying in harness scheme is no longer there. They have to apply for this. You received it.
Can forward it to the government, to the.
No, it has to be by the person himself.
Yes,
It can't be given by a third party.
they have already submitted with the copy marked to us.
But then we can't do anything. It has to be adjudicated in an appropriate forum.
That's true.
That means even if the High Court, it has to be by a writ petition.
But to be skipped.
We just request the registry to return it back to them to be taken up in an appropriate manner. No, we'll take that into cognizance and we'll refer it back, return it back to her. She will have to do it in a manner prescribed.
Well,
Next para, the registrar within bracket judicial of this court is also in receipt of a letter dated 18/11/2025 written by Srimati Dhriti, DHRITI, Prova, PROVA, Roy, ROY, Borman, BARMN, who has projected that, who has stated that her husband served as a member, Foreigners Tribunal since 2015 till he expired on 3/10/2025 at the age of 58 years. And she has stated that a representation was submitted to the competent authorities for compassionate relief. Full stop. In this regard, taking note of the nature of prayer made in the said representation, comma, this bench, comma, taking up only infrastructure issues, would not be having jurisdiction to take up the prayer made in the said letter dated 18/11/2025. Stop. Therefore, comma, the registrar within bracket judicial may return the said representation back to the concerned person so the concerned person would be at liberty to take such steps, oblique measures as she may be so advised. Full stop. It is put on record that since the said representation dated 18/11/2025 is ordered to be returned, no copy thereof is being retained in the record. Next para. The learned counsel appearing representing the additional advocate general, assisting the learned additional advocate general shall communicate a downloaded copy of this order to the to the Public Works Department within bracket building most of the concerned authorities on receipt of the downloaded copy of this order shall share the same with the Joint Secretary to the Government of Assam, PWD, and to the Chief Engineer within bracket buildings, PWD, for doing the needful in terms of this order. Next para, the registry shall also transmit a downloaded copy of this order. So the additional advocate general shall also transmit a downloaded copy of this order. No, again, mistake. The learned counsel assisting the additional advocate general shall shall transmit a downloaded copy of this order to the Home and Political within bracket B department to bring it to the notice of the Commission Secretary of the Government of Assam, Home and Political within bracket B department. Next paragraph. The authorities in the state are reminded that if the matter is not taken up expeditiously, the budget session and it's not placed before the authorities within the budget session, there is every likelihood that the infrastructure of the foreigners tribunal functioning in the state would not be improved. And the which will have a telling effect on the efficacy of the tribal's functioning. Next para. List again on 6/1/2026. So please communicate with the additional advocate general. Please get a copy of the order. You please do the needful. We have made it clear that if the budget session is lost, then the functioning of the tribunal will come into question. This, especially the Dibrugarh for shifting, please take immediate steps. Please have, just say in that Dibrugarh place, the PWD authorities who are present shall cause an immediate inspection of the foreigners tribunal Dibrugarh second, and to take immediate steps for redressal of the grievance. and request for shifting of the tribunal to a safe and adequate, to a safe and, to a safe and separate and it's a safe place for conducive functioning of the said tribunal.
On 6th, my lord, after getting the records or my lord detail,
Uh-huh.
we'll try to get a timeline from the PWD authority.
No, the estimates will have the timeline.
Yes. Well, I had no timeline with regard to implementation,
Okay.
because that has to be there.
Actually, just in the last of that part, you also say, where you requested the officers to take note of that. There you add, the authorities shall also be ready with the timeline within which they propose
Yes.
to complete the infrastructure works of the foreigners tribunals in the state. Okay,
2 PM. At 2 PM.
at 2 p.m. This one so preferably at 2 p.m. Mr. Dhar, here, although the court master has made an attempt to serialize all the documents, but it appears that it is still haphazard. The communications, you see, what we have done is, the order sheets are in a different file. The pleadings and affidavits are in a different file. But all these communications which are coming are lying in 3 other files. So we want those files to be serialized in serial order so that, what has happened in the meanwhile, when we call for the documents, they come with the office notes. So the office notes are also intermingling with the records. So if they can be serialized, you have given us a letter. This 1749 is given by the Additional Advocate General. Please return it back to him. And this letter to be returned to the writer. This is also given back.
One copy of mine, that 311 report, chart type report that,
311.
yes, my lord, this was my copy I have given.
Oh, yes.
Lord, the court master can make a copy of it and give it to me.
We definitely have it.
It has to be there in the records of your lord.
It to Advocate General. It to 311 is by H.K. Das. Sure, one more line. The learned advocate, Additional Advocate General has produced a copy of letter dated 1/12/2025 issued by the Joint Secretary to the Government of Assam, political within bracket D, the bracket whose department. Which contains a minutes of the meeting held on 28/11/2025 and data regarding registration and disposal of FT cases as Annexure A and Annexure B to the said letter. The said, the same are made a part of record. Actually, there is one more issue. Before this direction to them to appear, before that it will come. To say that the one of the issues which was flagged in the previous order, in the earlier order, I think it dated 2/9/2025. Was with connection of functioning of Foreigners Tribunal of functioning Foreigners Tribunal Yemak for Kamrup district from Guwahati. Post of the Home and Political B Department shall also address the court on address the court on the next date on the said issue. Next para. The other matter which was taken up by order dated 2/9/2025 relates to preparation of a standard operating procedure for all the foreigners traveling in the state. The Home and Political within bracket TPE Department shall also address the court on the next date of listing on the said aspect. After that, transmit the copy of the orders and so on. Okay. And then this copy of letter dated 6/11/2025, which so and so, as well as letter dated 1/12/2025 received from Northeastern Law House. I made a part of record. This was agote. This we have already given, made a part of record. This letter was also two letters. And third is that letter by produced by the Advocate General, Additional Advocate General. It's the okay. Thank you for joining online. You may disconnect now. Next date is fixed on 6th of January, requiring your physical presence of your officers or the delegate of the chief engineer building.
Thank you, sir.